Howdy, and welcome to the Legal Hour with Bailey and Galyen. We're here today at the Legal Cafe at the corner of Main and First Street here in downtown Fort Worth. And I'm with Kim Smith today. Kim is an attorney at Bailey and Galyen, specializing in workman's comp cases. Hi, Kim.
Hi.
You've been with us since, I guess, 2013. Tell us a little bit about yourself and how you got into this.
Yep. So I started out at a practice in Houston, and then came to the DFW Metroplex in about 2004. My own law firm, and then joined Bailey and Galyen in 2013. I have limited my practice area since coming out of law school to just workers' comp insurance in Texas.
Well, let's talk about what workers' comp is. We hear it all the time, but I'm not sure everybody knows what it is.
So workers' comp insurance is basically an employer gets to, they provide work comp insurance coverage for their injured workers. And it's to help, protect anybody that gets hurt at work.
Okay, is it mandatory in Texas?
Unfortunately, it is not. Texas is one of the only states that it is not mandatory. So an employer can choose to have workers' comp coverage or not have workers' comp coverage.
What would an employer base their decision on?
So maybe their liability, if it's going to be a type of work like construction type work where you're going to have a lot of people getting hurt or accidents happen, I would think if as an employer I would want coverage under those circumstances.
Okay. In most cases, can the employee file a lawsuit against their employer if they get hurt on the job?
So if your employer or if the employer has workers' comp insurance coverage, in most cases, you cannot sue your employer, even if it was their fault. If it was your fault, it doesn't matter. It's just you cannot sue them if they have workers' comp coverage. And in my opinion, basically, an employer gets the work comp coverage to protect themselves against lawsuits. And if they have workers' comp, then you have to get your benefits through the workers' comp system.
Okay. So for the rest of what we're talking about today, I guess we're going to assume that the employer does carry and pay for workers' comp insurance to protect their employees and to protect themselves from liability.
Okay.
Okay. So what would an injured employee be entitled to if they were hurt, or does it matter the extent of their injuries or the length of their injury?
So what they're entitled to, if the employer has work comp coverage, they're entitled to medical benefits, medical treatment for their compensable injuries, and there's a lot that has to do with that. But as far as so the compensable injuries, and they're entitled to money benefits if they're unable to work.
Okay. What are compensable injuries? That sounds like a legal term that we throw around a little bit.
It is, and sometimes when I talk to our clients, if they know what that word means, I know they've already heard it from the insurance carrier. Basically, a compensable injury is the injuries that the insurance carrier feels is related to your claim. So the insurance gets to decide what injuries are included or what the severity of the injury. So I find in my experience, most cases the insurance carrier does accept the minimal, not severe conditions. And some examples is like if you have a sprain to your back, they may accept the sprain or a contusion, which is a bruise, but they don't want to accept anything more significant. For example, you had an MRI, now it shows that there's disc involvement. The insurance generally limits your injury to sprains, strains, contusions, so that is the compensable injury, and anything over and above that is considered extent of injury. So if you've got to fight for the more severe condition, extent of injury is what that is. As far as medical treatment to the compensable body parts, it's what's deemed reasonable and necessary. So anytime your doctor wants to provide treatment, they've got to they'd have to request pre-authorization in most cases for the treatment that they wish to, for you to do. So whatever they considered reasonable and necessary via the insurance, the doctors should be able to provide.
Do you find that the insurance carriers in these workman's comp cases, how motivated are they to limit their payout?
So if you go to who their client is, which is the employer's paying for the policy. So I would think their goal is to keep expenses and costs as low as possible. So in my personal opinion, I think that they're very motivated to not pay and to keep it as minimum as possible. And usually the goal is, I honestly, Keith, I wouldn't be here being able to help people if there were not so many disputes and denials by the insurance. If they actually did what they were supposed to do, you wouldn't need an attorney.
Was it a circumstance of, someone is injured at work, a scaffolding falls on them, and they say, I've hurt my back. Are the insurance companies trying to argue that you already had a bad back, we're just talking about the bruise you got today?
That is in a lot of instances, and I've been doing this about 24 years, and I will tell you that they will downplay the injury. It's a bruise. And if any coworker ever heard the example you have that talked about, I play soccer with my kids, all of a sudden there's this whispering, maybe he did it playing soccer with his kids. And I know that they see what happens, but as far as the more severe conditions, lots of disputes that say that it's pre-existing, it didn't happen here. And what's appalling, Keith, is he worked fine 10 years for this job, 10 years, no problems. The scaffolding falls on him, and now he can't get out of bed, and there's going to be a dispute as far as the severity of that injury, because they're going to try to claim it's pre-existing. You're an old person, older guy, you're not a spring chicken anymore, this was going to happen anyway.
Well, let's say that this fellow has the scaffolding fall on him and he's hurt, and he's going to file his claim with the workman's comp provider. Should he go to a doctor?
You should for sure go to a doctor. So in workers' comp, you've got network and non-network cases. Network, you cannot just go anywhere you want. You have to, that insurance carrier is subscribed to a network. It's kind of like your HMO versus your PPOs. So you have to see a doctor that's approved on their list.
Okay.
Which makes it very difficult for a lot of injured workers, especially if there's not one really close to them. Or some insurance companies, the only providers they use is like a Concentra, Care Now, which are urgent care facilities, like you're in and out. And these insurance carriers, particularly one in Texas, prefers to solely use Care Now and Concentra facilities for any of the injured workers, and they're on a network, which definitely limits the injured worker's ability, because I don't feel like those providers, my client's best interest in what they need treatment-wise is no longer a concern. It is, what will the network let me do as a doctor? I'm not going to make this network mad, because God forbid if I do, they're going to kick me off, and now that provider can't treat in that network anymore. Then you have your non-network, which is the providers where anybody that accepts workers' comp, as long as the provider takes workers' comp, you can go to that provider.
Well, it would seem to me that some of these urgent care facilities, we used to call them doc in the box,
Exactly.
may not have all the imaging equipment and other tools that they would need to provide complete treatment to patients.
And it's funny that you mentioned that, because a lot of these facilities don't go and try to diagnose and find. It's just it's an urgent care facility. You have a broken bone, let's figure it out. Scratch, put a bandage on it. There's no further investigation or diagnoses. And you think these doctors, they take a Hippocratic oath, but their oath really is to the network and the insurance company that they're in network with. So you don't find a lot of MRIs being requested, or treatment that would help diagnose what's wrong with you. And with that, therapy or referrals to orthopedics or referrals to a specialist. It kind of stops in that box.
Well, and it'd be my understanding that most of the care facilities like that are not going to have specialists. It's urgent care, it's trauma, it's ER stuff.
Correct. And if there is in that rare opportunity that they need to get a specialist, guess what? It's got to be in the network.
Okay, so if someone's injured, their avenues for redress, I'm guessing, have to start with the insurance company.
Correct.
All right. When would be the appropriate time for someone to contact you?
So I talk to a lot of people all the time, and they don't need an attorney yet. And I will be the first one to tell them, you don't need one yet. Where I think that you would need an attorney is if the insurance is denying your claim, you filed your work comp claim, you reported it, and the insurance carrier has now filed a dispute, and you have to go, and you're going to have to go through the hearing, to a hearing and litigate your case at the hearing. It's an administrative level hearing, so it's in an office setting. The first level is a benefit review conference. It's Zoom. Second level is in front of a judge, but you will have to go to a hearing, and you're the one that has to kind of start going down that route, and no one's going to do it for you. So when a case is denied, or if you have an issue where they've accepted a bruise, but it's more than a bruise, you've strained your muscle, and they don't want to cover that, they won't let your doctor treat you for that or cover the payment of treatment for that. So that would be a time that you would need an attorney.
So at the get-go, who is making the determination of the extent of your injury and what is reasonable and necessary treatment?
So it should be a doctor, but a lot of those adjusters think that they have MD at the end of their name, and these adjusters, they make a decision and then they go get a doctor to back it up. A peer review, usually these are the same group of peer review doctors that the insurance uses to support their decision that the extent of injury should be limited to what the insurance has accepted, which is usually a minimal injury.
Okay. What are indemnity benefits?
So indemnity benefits are your money benefits. So if you are unable to go back to work, or if you have restrictions but your employer doesn't have work for you, or they can't accommodate your restrictions, then you're entitled to a weekly workers' comp benefit check.
How do you get paid that? And
So-
who figures it up?
So the way it's figured is they look at it, they basically take an average of the 13 weeks of your wages before the injury, gross wages, so before taxes, and it's an average of 13 weeks. There are maximums and there are minimums, and it's a weekly check. The insurance sends it out to you. As the injured worker, they send it out, but that's generally how they're paid, weekly.
Okay. What is a AWW?
So AWW is the average weekly wage, and this is any injured worker that's receiving benefits or might receive benefits under workers' comp. You should always calculate that average weekly wage, because the insurance is relying on what the employer told them. It could be before you ever got a raise. It could be whatever they started you at, your starting salary. It may not include your overtime that you work. So it needs to be a good snapshot of the 13 weeks before the accident. And there's times where 3 weeks the company shut down. That's going to affect your average, and it shouldn't be included. It should be what your usual, work, the regular rate that you would usually make. And I will tell you, a person that started a new job, the first hour gets hurt, is entitled to workers' comp. You don't have to be worked for the company for 13 weeks. They can use similar situated employees' wages,
Okay.
but there is a way to figure out the wages.
All right. If you go see the doctor and he says, all right, I want you to do light duty for the next month. Don't pick up anything over this amount of weight. How does that work with the company?
So, as an injured worker, you want to make sure that your company is aware that you have some restrictions, whether that be letting your doctor know to fax the work status report. And it's all based on that work status report. It's a DWC Form 73, and it's got what you can or cannot do. But your employer is required by law to provide you an offer in writing of light duty if they have it. Not all of them have it, but if they do want you to do light duty, it needs to be in writing, it needs to be sent to you, it needs to include a description of the type of work that they want you to do, including the physical requirements. What are you going to have to do for that job? Merely just repeating what your restrictions are is not going to get you there. They have to do this, and I want viewers to understand that, because if Bob the boss says, Jack, I need you to come in tomorrow, you got restrictions, we'll find you something. Just come into the shop, we'll find you something to do. The light duty needs to be in writing, because that protects you as an injured worker. Because if they're like, hey, Jack, there's this truck that just came in, can you help and give us a hand to unload it? You should have your light duty restrictions there that says, no, I can't lift over 5 pounds. I'm not supposed to do that. And I know everybody, you want to be a good employee.
Sure.
You want to help the job out, but
Right.
Just percentage-wise, the job usually doesn't help you out when it comes, you get hurt again, or now your condition's worse, and it can cause issues. So demand that you get that offer of light duty. Make sure it's in writing. There's 6 things that it has to require. It's good to go over that with an attorney, so that you know that your rights are protected. And a lot of people are like, but Kim, what if they fire me because I refuse to lift a 50-pound box even though I'm not supposed to do that? You know what? Then that becomes an employment law issue. And if they terminate you for that, let's look at your rights for that. Because if you were wrongfully terminated while you have this workers' comp claim, that's a whole nother lawsuit. So don't be afraid to say no if it means protecting yourself and you not doing something that could cause further damage to your body. It's your right. They have to provide you an offer in writing. Don't accept a verbal. Don't just show up and hope that they're going to let you do something that won't hurt you. That's why it's required to be in writing.
Do people get fired regularly?
They often get fired. What they cannot do, one of the things they cannot do, and we see this but not as often, is if Bob the boss said, Jack, if you go file this workers' comp claim, we're going to fire you, so don't file it. That's pretty blatant, and that is you definitely call us regarding an employment law issue with that. But what we do see is when you're off work and you're trying to recover and you're going to doctor's offices, without going into further a lot of detail with FMLA, but the employer doesn't have to give you your job back. They can release you. They have to fill their position, and a lot of people are shocked when they find out, well, they can't fire me if I'm hurt on the job, can they? They can basically tell you by this date, if you're not 100% and you can't come back to work, we're going to have to release your job position. Feel free to come back and apply when you're 100%. They most certainly can do that.
Sounds like an awkward position for an employee. You're coming back, I can't lift anything over 20 pounds, and the boss says, that's fine, we won't ask you to. I need that in writing. I would think that'd be a tough conversation to have.
It is a tough conversation, and a lot of people, by the time they call me, they've been trying to muscle through the light duty that the employer says they have, and they're like, Kim, they're making me do stuff and I'm hurting. First, you should tell your doctor. Tell your doctor that they're not sticking to the restrictions. And any doctor that is concerned is going to either reach out to the employer or the insurance carrier. If you have an attorney, that attorney should be doing that for you. But we get a lot of cases where the ball already started rolling. They're trying to do the light duty, but you're right, it is awkward, and that's why I hope that if your boss says you need to come in, let's talk about light duty, that you do let them know it's supposed to be in writing. I need this in writing, and by then you should have an adjuster. You should tell the adjuster, if you don't have an attorney, let the adjuster know, hey, they want me to come to work, but I need it in writing. They can email it to me or mail it to me, certified mail, let me get it, but I need to review it. And they got to give you a little bit of time to review it. So they can't give it to you and say, you need to sign here today. You should be able to take that with you. It's a date that, come back in about, the start date's about a week from now. And there's a lot of little things that, that you would need to know and know to ask. But remember, you've got to look out for you.
Okay. Well, what if you've got a position where you're doing some physical stuff, and let's say you're making $25 an hour, but now you have to go to light duty? Can they say, well, there's a desk over there, go sit over there? Of course, that's minimum wage, but you'll have something to do.
So we do see this, and what would happen is you'll go work your 8 hours or whatever with the minimum wage payment. Don't panic. The insurance carrier has to pay you the difference to make you whole, back to that average weekly wage. So if you're making $200 a week from this, and they've got you on minimum wage, the insurance carrier's got to, do the math on that average weekly wage, and you're paid partial payments. So it's okay. Don't panic if you're like, I can't do minimum wage. It's not going to pay my bills. Well, the insurance, so you'll get 2 checks basically, your regular payroll check, and then you'll get your workers' comp check to pay the difference.
Okay. I'm an employee. I have my own doctor. I've had my own doctor for forever. Okay. When I get injured, the insurance company wants me to go see their doctor. What role does my doctor have in any of these discussions? Does he get a say? Does he get to have any input?
So usually, if it's, we're talking like your PCP, a lot of them don't take comp. So as soon as you utter the words "hurt at work," they're gonna, no, we can't, because Blue Cross or United Health or whoever your insurance plan is gonna say no to that you need to go treat with a workers' comp doctor. There are some instances where a family doctor does take work comp. Not an issue as long as it's not a network. So non-network you can't. But 9 times out of 10, you go back to your family doctor and they will tell you immediately, we don't do workers' comp. Don't blame them. It's tough to get treatment there. But you need to go find a workers' comp doctor.
But it would seem like my doctor is going to have records and be aware of my physical conditions and what medications I'm on and things like that. And it would seem like they would have a wealth of information that you would want the treating doctor to have access to.
That makes total sense. And usually when we get these denials where the insurance is claiming that it's pre-existing, we do ask them, can we bring in your PCP records so we can show that there's never been any treatment for this, that these conditions are new. It's helpful. But there are some people that are like, I don't have a doctor. I go to the ER if there's an emergency, but other than that, flu shot, I don't have any issues. But you would think sharing the information would be helpful to the treating physician.
Well, yeah. Does the injured worker have to pay his upfront medical expenses, or how does that happen?
So the insurance carrier pays the providers. It does not. It's not a check to the claimant, and the claimant goes and pays for the medical. It's nothing like that. The claimant is entitled to the indemnity, which is your weekly check due to loss of income from the injury, and then the providers bill the insurance carrier directly, and they are paid by the insurance carrier. So there's no cost to the injured worker.
Well, what if I want a second opinion?
In some circumstances, you are entitled to a second opinion, and the insurance carrier has to cover it. But it's only in some limited circumstances.
Wow.
Or you can change providers if you don't feel like your provider has your best interest, assuming it's non-network.
How many folks have problems with the workman's comp circumstances? I mean, yeah, and I'm just saying, maybe out of 100 people who are injured at work, how common is it for the workers to have problems with the workman's comp carriers?
It's highly, highly likely that they will have a problem with their case. If not immediately, later on in their case when it comes to getting their, impairment rating, or, you're trucking along getting treatment and all of a sudden the carrier files a denial that we're going to pay for the neck, but you never said anything about the back. And if you did, you only mentioned it once at the very beginning. We hadn't heard about the back since then, so we're not going to cover the back. Things like that. So, and what's scary is there's a lot of people that call me that I can't help because they waited way too long to get help for their case. They assumed that the insurance adjuster was going to take care of it. They assumed that their best interest was the insurance carrier had their best interest in mind. But you have to remember the person that's paying for that policy is the employer. That's really their client.
Well, if I'm getting treatment, can the carrier just simply say, we think 3 treatments is enough, you're done?
So what they do is they'll get a peer review doctor or an RME, which is a required medical evaluation, and a doctor will usually 9 times out of 10 give the opinion that, you know what, you've already received all the treatment you need for this condition. And it significantly limits what they get to do next. It ties their doctor's hands. They're unable to get treatment. And there's a lot of people that after that point then go to their PCP because the insurance, the work comp insurance won't cover it. So that's when they call us or they start to seek, want to get help. If I had one thing that I would like to tell people is know up front what those compensable injuries are. Ask your adjuster, what is considered compensable? What have you accepted on my claim? Because then you're better suited to go to your doctor and say, A, B, and C injury is what they've accepted. And then between you and your doctor, you might, Jack, you need condition F and you need additional treatment for these other conditions. And you both already know it's only A, B, and C. So there's an extent of injury argument now because the insurance isn't going to cover all the different conditions or issues that you're having.
Well, if I'm an employee, I'm assuming, and I probably shouldn't, that for the purposes of this question, that I have health insurance as well through my employer, okay? So I have health insurance through my employer. I'm injured at work. They make a determination of what injuries are compensable, what the extent of those injuries are, and they say we're gonna help you with injuries A through C, but on D, E, and F you're on your own. Okay, so I go back to see my personal physician under the umbrella of my healthcare coverage. Is the fact that there's a workers' comp case going on or workers' comp injuries being treated going to impede me in any way from getting the other help I need?
Very good question, Keith. We hear this a lot and a lot of our clients are stuck in this crevice. So A, B, and C is accepted. Injuries, conditions A, B, and C are accepted under work comp. They file denial disputing D, E, and F, and I tell my clients, there's the denial sheet. Take that to your private insurance and say, I want treatment for D, E, and F, because the insurance has already said it's not covered here.
Okay.
On paper, they should be able to go treat with their private health insurance. Go get treatment for that.
But in practice?
In practice, a lot of insurances, nope, we smell that it's work comp. We're not going to touch it. And it forces the injured worker to either go litigate it on the work comp side, or you have to go look at your doctor and basically tell them, nope, this isn't work comp, which they can say this is not work comp because the insurance hasn't acknowledged it. So I call it a crevice because they get stuck in there and they'll find, they're unable to go to the private health and they can't go to the work comp side. So they're kind of stuck, and we get a lot of people. That is one of their issues. So,
what is a letter of causation?
So, if an injured worker is wanting to pursue a more severe condition, assuming your claim's accepted, insurance is accepted a minimal injury, but your doctor's telling you and you know that this is significant. You didn't have these problems before you got hurt, and now you have numbness in your leg, or you are just not functioning like you used to. In order to pursue that, you need a letter of causation. You need a doctor that is willing to review the records, understand how you got hurt, and write a letter that explains that. And the way I tell my clients is, think of it as the play-by-play. It is not enough to be diagnosed, let's just use lumbar disc injury. It's not enough to be, you can have a stack of medicals that diagnose that all day long. But if you don't have that one page or a few page letter of causation that explains how your mechanism of injury supports the condition, and the best way I can do this is give you an example. And this is how the letter would address this. So I got a 50-pound box going down the steps of my bus, and as I plant my left foot on the ground, my ankle rolls, my left elbow hits the rail, and then I bounce back to the right, and I fall face forward with that box under me, and it just kind of flexed me over the box. I roll over, I bang my head back, and let's just say it's a head injury that they're disputing. That doctor's got to write how you got hurt, play-by-play, slow motion, and how that head hit the ground and caused the contusion on the back of your head that the insurance is denying, or let's just say that you're claiming a concussion. And the insurance is like, no, we don't see how that would have caused it because it's a knee injury. You twisted your knee and in your ankle, so how's it up here at the head? So a doctor would step aside, get the records, write a letter. Where we see this the most is shoulder injuries, knee injuries, back injuries, neck injuries. That need for a letter of causation. You have to have that if you're going to claim a more severe condition. Without it, your success rate in front of a division administrative law judge is slim to none.
I have seen too many times. It's happened to me. Okay, I hurt one leg, and the next thing I know, my hip and my lower back are killing me to the point I have to use a cane, okay, because I'm having to support myself and walk so differently because of the injury to my leg that it starts affecting my gait and everything else. How do you deal with something like that?
So usually those come up as a extent of injury issue. I will tell you that, let's just say it's your left knee and you got out of bed at home and you put your weight on your left knee and it caused you to fall and you banged up your shoulder real good at home. Kim, is my shoulder now, can I claim that under work comp? You cannot.
Okay.
You cannot. They're very difficult.
Even though that's the injury that occasioned it.
So it's not a but for.
Uh-huh.
You can't say but for the knee that caused my shoulder. Not under state workers comp.
Okay.
But the altered gait, I have several cases right now before judges with the altered gait. So it is going to be an extent of injury issue. And then, again, that's another thing that the insurance carrier will deny.
Do you help folks? I'm guessing somebody gets hurt and something is said to them about the workers' comp claim and it makes them nervous. Do you have a lot of folks come to see you and say, all right, walk me through this because I want to make sure I make my initial report the right way? Would it help if they did?
Yes, so you want to make sure, so there's a couple of deadlines in workers' comp, and one is you want to make sure you notified your employer within 30 days of knowing you were injured. Sooner than later, and a lot of people are like, I don't want to, especially my guys, they're like, I don't want to be a wuss, I'm just going to, I'm sore all the time.
No pain, no gain.
Right. And they don't want to make a big fuss, or they're afraid they're going to get fired. We've got people that, I just started here and they didn't show me how to use this forklift real well, and I messed up and I got hurt, and I don't want to say anything. Say something. And report your injury as soon as you're aware you got hurt. Even if it's a text to the boss, even if it's a phone call to somebody, it's got to be someone higher up. So it can't be a coworker. Don't just chitty chat, but make sure you tell your employer, report it, no matter how small. Example, You got a little nick on your arm because you were up in the attic doing AC work for your company. It's a little nick. You didn't report it. You put a Band-Aid on it. 2 days later, you're in the hospital. Sepsis. You've got an infection in there, and you never said anything when it happened. So now you've got this infection, and all heck is broken loose. You've got kidney issues. They've got you, and you're fighting for your life. We had a case like that where they didn't think anything of the nick, and they never reported it, and it wasn't. We had to fight that, and we succeeded. But that person had kidney failure. He's going to be on dialysis for the rest of his life.
Oh.
All because of a nick. So report your injury, no matter how minor it is. Report it. Let them know. Remember dates, and just get it reported. You have 30 days, but let me tell you, that 30 days flies by, and I have I can't help you if you didn't report it in 30 days. You will not have a workers' comp case. That is probably the number one. I can't help you is they went 6 months and tried to just handle it, and now all of a sudden they've got to miss work. Doctors want surgery, and now they're like, well, how am I going to get paid if I can't work and I need surgery? I'm going to go report this. 6 months later, I can't help you.
Wow. Let's talk about different kinds of injuries. Repetitive injuries, occupational diseases.
So there's two types basically, is your occupational disease, which includes repetitive injury, exposure, inhalation, and then you have your specific. If you can remember the date and the time and what you were doing when it happened, that is going to be generally your specific injury. If it's over a period of time, you're doing the same thing, and on one day, the straw that broke the camel's back, I will tell you that the adjusters love to get you on these. If you're claiming a repetitive injury, adjuster turns on the recorder. When did you start feeling symptoms? Shoot, probably, I don't know, about 6 weeks ago. All of a sudden, that's your date of injury. And guess what? Where's that 30 days?
It's been expired.
It's blown. Now your claim is denied. So there's a big difference between when you started feeling symptoms and did you know those symptoms were work-related. And I call it the light bulb moment. I tell my client, at what point did you connect you being hurt with the work? And it could be when you got an MRI or your doctor says, you know what, Jack, what do you do at work? Tell me about what you do at work. Jack, this came from work. And that is your light bulb moment. And it may be weeks after you started feeling the symptoms. So you just got to be careful with that. But generally, your repetitive type injuries, it's the moment you realized that your condition was work-related, not when you started to feel the pain. And then, of course, the specific is you remember what happened, what you're doing the moment that the ouch happened. When
do you want to see somebody? If someone's hurt in an accident at work, let's leave it a simple case of I fell at work and this happened. Okay, when does an injured worker really need to consult counsel?
I would say anybody that got hurt or anything, even with the person that got nicked, just our office will talk to you. We will call you. Give us a call. We will make sure, and this is information you can get without even hiring me. Just make sure that you already reported your claim, you filed your notice with the division, and I will tell you, I'll be the first one to say, let's wait and see if they're going to dispute your claim. If they accept it, then you never needed an attorney. But here's my information. Call me if this happens. Get a hold of us if this happens. You can always call and talk to us. We will try to provide you as much information as possible. But as far as when should I hire an attorney? When you start seeing denials, when you're not getting the treatment you should be and your doctor's wanting you to, or when your doctor stops listening and you know your body, and you know that if there's issues that you don't feel like your doctor's on your side anymore, give us a call. If you're not sure about the money you're getting or your checks have stopped, and I've got to tell you, I've had so many people that, and you panic. Your checks stop or you can't work. When are you going to see some money? How are you going to pay your bills? Because your bills don't stop.
Right.
Mortgage, rent, that still comes in. Kids, family needs to eat. that still happens. So there is a slight waiting period with the injury when you report it, but just call an attorney, call our office. We'll be glad to talk to you. It costs nothing for you, and if you get any information that helps you, figure out what to do next, that is, at least you have more knowledge than you did before you called us. At least you can get information, or you can call the Division of Workers' Comp, speak to customer service, and try to get information that way. There is ombudsmans there, but remember, they will help you to a certain extent, but they will not represent you.
When you're going through these hearings, you've gone through the administrative route, and the client has been denied, and you take it to the next step, right?
Correct.
And that's where you're with a judge and you're presenting your evidence. How does that system progress?
So there's basically 2 levels of hearings. The benefit review conference, which is by Zoom, and it's, you don't have to be IT savvy to do it. You can call in. They do have a number to let you call in and you join the meeting. But that's the initial level. It's more of a time to talk, see if we can resolve it, know what the carrier's position is. They can hear what your position is. And if parties are unable to resolve the issues, then it's set for the next level. That is called a contested case hearing. And again, that's that office setting I was telling you about. There's a judge at the front. The insurance carrier has their desk. You have your desk. And y'all face the judge. And it's very informal. But a judge would make a decision on your case. At the benefit review, BRC level, no decisions are made. It's just a place to help facilitate trying to work things out. I will tell you, I don't have a lot of BRCs that work things out. If they were going to work it out, they would have called me before the hearing. So right. Unfortunately, most of our cases, they go to a contested case hearing, and we're in front of a judge. You present your evidence. The decision is not that day. You get a decision mailed to you after the judge has reviewed all the evidence, and then they make their determination, and you get your decision in the mail.
So Kimberly, tell me about impairment ratings.
So impairment ratings are basically when you've gotten your treatment and a doctor says that, you know what, you're as good as you're going to get. No therapy, no surgery is going to improve you significantly. And at that point, a doctor will come forward and basically say, you've reached what they call maximum medical improvement. You're as good as you're going to get. And they give you what it's called an impairment rating. It's a percentage rating. There's really only 3 doctors that will do it. It'll either be your doctor or the doctor they refer you to, one side. The designated doctor, which is a doctor that is appointed by the state of Texas that's supposed to be unbiased. And then there's the insurance carrier doctor, the RME, required medical exam. And so any of those doctors can give you what we call the impairment rating. There's only a few deadlines in workers' comp, and this is one of the ones that will get you, and it gets a lot of people. Is you've got 90 days to dispute this if you don't agree with it. And a lot of clients, what I find is they get the impairment rating, and the doctor gave them like a 5% impairment rating, but their checks didn't stop, so it kind of was seamless. So there was no red flag, nothing for them to be, because they transferred from temporary income benefits, which is where you're off work, to an impairment benefit, which is the same amount. The amount does not change. It may go down, but it's basically the same amount. There are maximums, and that's a whole other thing. But there's nothing to raise a red flag with the claimant that anything has changed until that check stops, which could be 90 days later.
When it's too late.
When it's too late to do anything. So as I mentioned, there's two types of cases that I really can't help. One, if you didn't report it within 30 days. And 2, you come to me with an impairment rating and your doctor's like, Kim, my injury is more severe. This doctor didn't rate everything, but the 90 days has already passed. There's nothing we can do. Now, injury-wise, you can still argue additional conditions, but the impairment rating is done. Your money benefits are done. So even if you got other conditions in there and you may still need treatment and you might be off of work for them, you won't get off work money benefits anymore for that. Wow. So you gotta just, you get stuff in the mail, it looks like everything else. So you've got to know that if a doctor's sending you for what they call MMI or IR, that's maximum medical improvement or impairment rating, and you gotta watch that 90-day. Even if you don't like it, or if your doctor doesn't like it, you've got to file a dispute, and it requires certain form filings in order to dispute it. And
as a lawyer, I will just add, we've seen this way too many times when someone says, well, I didn't open all those letters. They just look the same as the ones they've been sending, so I didn't bother opening it. People get burned doing that quite a bit.
Yeah,
So,
fortunately.
Kim, how can people get in touch with you?
So you can go to our website, Texas Attorney, and we've got this legal cafe that we're here today at. They can come in our office, any of our offices, any of our locations. You can go in any of the offices. We are based out of Arlington for the work comp department, but we have offices all over. As far as phone number, they can call 817-857-6277 and mention that you saw us on the podcast today, and we are offering what I am calling it a public service where we will help people dispute the 90 days, at least get the hearing in there, because by the time you get with an ombudsman who, if they call you back, if they get back to you, your 90 days is gone. But give us a call at that number, and we will review it, and we're offering that just the service of, we'll help you file the hearing. We may not be able to represent you, but at least we will get that hearing submitted for you so that 90 days is taken care of. And you don't, now you can go forward with focusing on getting your other information together. And again, this is just a tip of a very, very large iceberg of things. There's a lot of little nuances in workers' comp, but I would strongly, if you get hurt, which we hope you don't, but if you do, give us a call. Let us just talk to you about your case to make sure that you've done what you're supposed to and figure out where the insurance is. And like I said, you may not need an attorney, and we will be the first one to tell you that. You don't need one right now, but we'll kind of give you what little milestones to look out for, and then circle back to us and keep our number handy. Again, mention that you saw us on the podcast today, 817-857-6277, and we would be happy to speak to you about your case.
And it's a free call.
It is a free call.
So knowledge is power.
It is.
Again, thank you for joining us on the Legal Hour. We'll see you soon.